the legal weaponization of commercial paper, and how every transaction can be rewritten. What if every transaction you've ever made, loans, leases, purchases, could be rewritten using one tool? That tool is commercial paper, and under UCC law, it's not just paper, it's power. Here's how to weaponize it legally. The term commercial paper, as codified under UCC Article 3, refers to short-term, unsecured negotiable instruments used in commerce, including promissory notes, drafts, and bills of exchange. What is not widely known, however, is that virtually every transaction you participate in, from opening a credit card to financing a car or home, is structured using this framework, often without your awareness or express consent. According to UCC Section 3-104, a negotiable instrument must contain an unconditional promise or order to pay a fixed amount of money. Yet, most consumers, when asked to sign a loan agreement, are never informed that what they are signing is in fact a negotiable instrument, created, deposited, and monetized by the lender. Once signed and delivered, this commercial paper becomes a private security. It may be sold, traded, pledged as collateral, or submitted to the Federal Reserve under Regulation A as part of the discount window operation. The original borrower receives no consideration in return and is never shown the actual accounting treatment or how the instrument is reclassified on the bank's balance sheet. This secret monetization violates the spirit, if not the letter, of 15 U.S.C. Section 1602G, Truth in Lending Act, which defines a finance charge as any cost imposed as a condition of credit. If the lender never gave actual value, but instead used your signature as an asset to generate funds, then you were the lender, not the borrower. As a result, every subsequent payment you made became an act of post-payment extortion, contractually voidable for failure of consideration. A skilled litigant or creditor, in fact, can challenge the entire transaction based on the non-disclosure of the commercial paper process. This includes asserting rescission under UCC Section 3-305 or invoking common law unconscionability due to fraud in the inducement. Additionally, under UCC Section 3-402, an instrument signed by an unauthorized agent may be void unless ratified, raising issues when entities such as MERS, servicing agents, or securitization trustees execute assignments and endorsements without full authority. If you can prove that your signed document was used as a self-paying instrument and that you were not informed of its commercial nature, you can seek to have the contract rescinded, damages awarded, and in many cases, obtain injunctive relief to halt foreclosure or debt collection proceedings. This turns every debt transaction into a potential financial remedy, not through evasion, but through lawful exposure of the commercial instrument's life cycle. Footnote: this section reveals how promissory notes and similar commercial instruments are weaponized through undisclosed monetization, allowing debtors to challenge contracts based on failure of consideration and lack of disclosure.